Hello, I'm Heidi Thompson, your Legacy Lifeguard with Lifeguarding Legacies. And I'm an estate planning attorney in Phoenix, Arizona. I serve pretty much all of Arizona and soon to add Florida. And I help clients to lifeguard their legacies. Today, I'm going to be talking about the 5 biggest mistakes that people make in estate planning. So let's just jump right into the water. The first mistake that people make is failing to avoid the ruthless rays of probate. So I don't know about you, but when I watch rays, either in the wild or in one of those aquarium petting tanks, I find them just mesmerizing. They're elegant the way that they just soar through the water. It looks effortless and they seem just harmless, right? But that is not Steve Irwin's experience. Now, you may remember him as the crocodile hunter, and he proved that even the most experienced nature lover can feel their fatal sting. Well, Frank's mistake was not quite so perilous, but it still stung his family. See, Frank made the first of our top 5 estate planning mistakes, and he believed that having a will was enough to be able to pass his house, and he didn't talk with a lawyer to ensure that he had any asset protection plan that would work. Now, the way that this happened for him is he owned a home that was titled only to him. So there was no survivor that was in the deed. There was no way to pass that home automatically. So it triggered a probate upon his death. So in Arizona, if you have $100,000 equity in your home or $75,000 worth of personal assets in just the name of the person that died, it does trigger probate. And that means that the court will go about starting the process to decide how your things are distributed. That means there's now a 4-month window when creditors get to swim around and make claims against Frank's estate. In the meantime, Frank's estate is locked up tighter than a tackle box, other than a few allowances and exclusions. This is likely to cost his estate at least $3,000 to $6,000, and if there's a contest, it can be tens of thousands and up. And it's a hassle and burden on family members that are really still grieving his loss. So it's important to know that a will is just a letter to the probate court. It tells the court how you want your assets to be distributed when you die. By itself, a will does not avoid probate. However, a will plus the right asset planning might have been enough. The house should have been placed maybe in a beneficiary deed or have been placed in a trust, like a revocable living trust. So let's talk about that trust for a minute. First, it's revocable, meaning that during your lifetime, you can change it around, move the assets in it, or rewrite the whole thing. Second, it's living, meaning that it doesn't die. Because it doesn't die, it doesn't go to probate. In fact, it can live on in Arizona for up to 500 years or until all of its purposes are fulfilled. So if you don't want to be Frank, make sure that you develop a good asset plan along with your will and or choose that revocable living trust. And don't make mistake number 1 of believing that a will do and fall prey to the ruthless rays of probate. Okay, so let's move into mistake number 2, which is failing to prepare for the jolting jellyfish of incapacity. Now, I'll just tell you, I've never been scuba diving. One time in Cabo, I went through the short training, donned the wetsuit, practiced the breathing, and was ready to jump off the side of the boat. But the water was filled with jellyfish. The instructor jumped in and was immediately attacked with these electrical impulses. And even just talking about it, I get some empathy pains. Some people believe estate planning is all about death, but that's mistake number 2, failing to prepare for the jolting jellyfish of incapacity. Now, you might be thinking that I'm talking about dementia. And if that's where your mind is going, you're likely to tune me out thinking that it's okay to procrastinate. But let's say you are in a serious car accident and then you can't communicate. The ambulance takes you to the hospital. Now, ordinarily, when you get to the hospital, you sign forms that say who the doctors can speak to on your behalf. You kind of take care of all of that when you're admitted. But when you're admitted and you're not able to speak for yourself, then you have to have documents that are already in place that allow people to talk on your behalf. Someone that's assigned to make your medical decisions, someone that can take care of the finances. So if you're over 18, you need to have these documents in place. If you don't, basically you're just like a foster kid. You're a ward of the state. Nobody but the state can make those decisions for you. And so to gain a legal voice, if you don't have the documents to give them away, your family members would have legal the high expense and legal fees and that loss of critical time while they go through the guardianship process through the court system. That stings, just like a jellyfish. And it's often sudden and unpredictable. But you can choose jolt free waters by putting together reputable will and trust plans that include those supporting documents of healthcare power of attorney, financial power of attorney, living wills, and HIPAA waivers. Let me underline one important point here. If you're an adult, you need at least basic estate planning documents. You may not even own anything, but you still need to provide that legal voice for your own care. The last thing you want is state making your healthcare decisions. I frequently get asked, when do I need an estate plan? The answer is on your 18th birthday, and then you need to review it every 3 to 5 years and with every major life change. So that moves us on to mistake number 3, not preventing the war-waging eels of family strife. Now, I found this National Geographic video on YouTube, and it shows 2 moray eels spinning around as they fight to the death. It's one of those, I don't want to watch it, but I can't take my eyes off it kind of videos. My mind went to a couple of teenage girls fighting over a boy, that here, hold my earrings. These vicious creatures were seeking to cause the deepest harm they possibly could. And that brings us to mistake number 3 in estate planning, which is really believing that the kids will get along after you die. There's an old joke in the legal world. Criminal law is bad people on their best behavior. Family law is good people on their worst behavior. And estate law is just family law with money. I've seen it. Families that seemed perfectly amicable, Thanksgivings and Christmases shared without a hitch. Then mom passes. There's always one object that at least 2 people want badly. One was promised it, the other might already have it in their possession, and then the fight starts to get ugly. We like to think we're not tied to possessions like that, but the sentimental pull of some object is just stronger than we might think. One lawyer even talked about how a family ate up a majority of a large estate when 5 children lawyered up to fight over a $3 vacation knickknack that had sentimental value because of the way the mom used it within the family. The only way to limit these disputes is with thorough pre-planning. Talk to your family members now, learn what objects carry that strong emotional value, and then while you're still alive, make sure that we've got in writing who receives what. That way you mediate those disputes so that it's not a problem when she's gone. If you make that plan, then you can leave with your soul and your family at peace. And that brings us to mistake number 4, which I call suffering the pirate's curse. Now, you might think, what in the world does Johnny Depp have to do with estate planning? Well, frankly, I love Johnny Depp. I think he's probably the best, most versatile actor of all time. There was a meme I remember from probably 10 years ago. It showed him in a bunch of his roles. And it said, they said I could be anything I want when I grew up, so I did. And it pictured all of the different things he's played, from that weird kid with scissors on his hand to an Indian, to Willy Wonka. And I think his most memorable role of all is Captain Jack Sparrow in the Pirates of the Caribbean series. Jack made pirates just likable. At the end of the first movie, there's the Curse of the Black Pearl. There's this scene where he and a bunch of cursed skeletal pirates find a heap of buried treasure. The coins were truly cursed if they were removed from the chest. In a similar vein, a large treasure can be a curse in real life. We all know the stories of millionaire lottery winners. They're very often broke 2 years after they bought the ticket, more so than they were before they bought the ticket. Most people just aren't conditioned to handle great amounts of wealth all at once. It takes years of training and positive habits to manage money well. And yet most of us will leave an inheritance that is just one lump sum. Even if that's just our home, It could be hundreds of thousands of dollars. In most cases, this is not leaving a legacy. It'll be used and cursed because it'll be spent within 2 years and maybe even leveraged to create more debt. So, planning mistake number 4 really is leaving lump sum distributions that create that pirate's curse. If you have large investments like 401ks, IRAs, large bank accounts, or real estate, think about how these might be divided and spread over time. In my case, I follow the Warren Buffett philosophy. You should leave your children enough so they can do anything, but not enough so they can do nothing. I want my kids to have to work for their living, but when I'm gone, I want their lives to be enriched by what I left behind. So my trust is set up to give an adjusted amount. I use the IRS gift tax exclusion, not because of tax reasons. There really aren't inheritance taxes in Arizona, but because it's a nice number. Right now in 2020, it's $15,000. That's $1,250 a month. That's below the poverty line, so it's not something someone could live on, but it's enough to buy a decent car every few years, enough for a kitchen remodel, enough for a few nice family vacations, enough to substantially enhance someone's life without changing it completely. Now, I'll confess the Secure Act of 2019 that snuck through right during the presidential controversy um, snuck through in December of 2019, and it said that inherited 401ks and IRAs have to be fully distributed and taxes paid within 10 years. So, if your beneficiary is under 18, they get to wait for those 10 years to start when they're over 18. And there's a few other provisions for disabled family members, people within 10 years of your age, those kinds of things. But in general, the inheritance idea that you're going to leave IRAs to your kids or these pre-tax instruments to your kids has been made more complicated. So if you have a large part of your wealth in IRAs, I think it's very important for you to meet with your advisor, your CPA, and I'm happy, or your estate planning attorney is very often happy to meet and team together to look at what other options you may have for some of the wealth that you don't believe you'll use during your lifetime. So those IRAs, maybe they can be converted into Roths so that they're not taxable to your kids, or maybe they're put into some kind of an insurance plan instead, where that can be something you can live off during your senior years, potentially with the investments, and then distribute easily to your kids in a structured method. So those are the kinds of things that we can talk about to make sure that even with the new complications of law, we can beat that pirate's curse. And one more thought while we're talking about protecting these distributions over your lifetime for your kids. Silver marriage can further complicate your estate plan. So you and your spouse created this great estate plan to structure those distributions for your kids, and then one of you passes. The other might find love again and choose to remarry, but the new spouse could come in and derail that family estate plan in favor of their own children. That happens a lot. And I can tell you with great estate planning, it is completely avoidable. So I jokingly call it in my practice the floozy clause, and I'm happy to talk that through if you want to have a follow-up conversation about what is the floozy clause. Obviously, that's not the legal name, but it is for exactly these kinds of situations. That brings us to mistake number 5, swimming with no lifeguard on duty. You see right here the image of Google, such a recognizable search. Now, I'll just tell you, my husband believes Google is the evil empire. He's a bit of a conspiracy theorist, and sometimes he's not that far off. I won an Amazon Alexa device as a door prize some time ago and can't even plug it in because we don't want to have our conversations listened to more than they already are. Even so, I can't tell you the number of times that I've either searched for something or even just had a conversation about it, and then it appears either on my Google ads or on my Facebook feed. It's a little creepy. And yet I still think Google is amazing. You can ask just about any question and get an instant and usually right answer. I'm old enough to remember trying to use an old set of Encyclopedia Britannicas to find the answers to my questions if my parents didn't know the answer. Now I hit a button and Google comes to the rescue. It makes perfect sense to Google a will form and fill in the blanks and sign it. And legally, it might hold up. Emphasis on might. You just don't know how old is that form? Does it really meet the needs of your family? Is it specific to the rules in your state? Does it take into account current law? Who wrote it? And were they any good at what they did? Now, I've been doing this long enough that I could probably create a will form that would serve its basic purpose. But even with legal training, I wouldn't use Google to do it. I subscribe to Wealth Counsel, which is recognized as the estate planning Cadillac in our industry. It's a great place for the basic core documents, for training, for community with other attorneys that answer complicated questions together. And Wealth Counsel works tirelessly to make sure that all of their documents are state specific and up to date. Not to mention, when you do Google your own form, there's no one to walk you through some of the impacts of what might seem like very straightforward questions, but that have very long lasting and maybe unintended consequences. And part of those may involve taxes. Now, Benjamin Franklin once said, in this world, nothing is certain except death and taxes. They certainly go hand in hand. But when you make a team with your CPA, financial advisor, insurance professional, and estate planning attorney, they're going to make sure that you have the strategies to take advantage of legal tax benefits. Now, some people think, ooh, taking advantage of tax benefits, and they criticize that as if it's some kind of illegal or sketchy thing. And my friend Jason Henderson, who specializes in insurance solutions that really do just that, he shared a Louis Brandeis quote just recently with me that I think perfectly explains legal tax avoidance. So I'm going to share that whole quote because I think it's just fabulous. Louis Brandeis says, I live in Alexandria, Virginia. Near the Supreme Court chambers is a toll bridge across the Potomac. When I get in a rush, I pay the dollar toll and get home early. However, I usually drive outside the downtown section of the city and cross the Potomac on a free bridge. This bridge was placed outside the downtown Washington, D.C. area to serve a useful social service, getting drivers to drive the extra mile and help alleviate congestion during the rush hour. If I went over the toll bridge and through the barrier without paying the toll, I would be committing tax evasion. If, however, I drive the extra mile and drive outside the city of Washington to the free bridge, I am using a legitimate, logical, and suitable method of tax avoidance, and I am performing a useful social service by doing so. For my tax evasion, I should be punished. For my tax avoidance, I should be commended. The tragedy of life today is that so few people know that the free bridge even exists. And that's where I would say making sure you're not swimming alone and making sure that you're surrounded by good financial professionals will make sure that you know about the free bridges that are so important to help you leave that legacy behind to your kids. So make sure you have a lifeguard on duty. A good estate attorney will throw you a lifeline that protects clients from dangers of the deep. So don't make estate planning mistake number 5 and swim with no lifeguard on duty. You would be swimming at your own risk. Speaking of swimming at your own risk, procrastination or trying not to think about the realities of this difficult topic is swimming in dangerous waters. For my clients, I make the process just like a day at the beach. I ask questions and listen to your answers. I create the plan and recommendations based on the solutions that make sense for you. I don't oversell, and I don't make you lift a finger. You won't have to fill out forms or even know what to ask. My pricing is straightforward and published on my website, and I always give you a free copy of my book just for the asking. The book information is on the last slide, so stay tuned, just 1 minute more. So I do want to just go back over the 5 mistakes in estate planning just to kind of jog the memory. First, we want to avoid the ruthless raise of probate, then the jolting jellyfish of incapacity, the waging eels of family strife, the pirate's curse of outright distribution, and swimming with no lifeguard on duty. I do hope that you'll stay in touch with me. You can reach me by email at info@lifeguardinglegacies.com. Visit my website at lifeguardinglegacies.com. Reach me by phone 602-529-1827, and I'm all over social media. And just for listening and staying with me, here's my freebie. If you will email me just the header subject line, I want the book, or get your book, or something like that, at my email address, info@lifeguardinglegacies.com. I'll send you my free book, Lifeguard Your Legacy, What Every Arizonan Should Know About Estate Planning. That book is $9.95 on Kindle and available in hard copy on Amazon for $15. But just for being with me today, please do email me and I will send that to you for free. Hey, feel free to check out my other booth, check out my booth at the health fairs. Feel free to ask questions. Feel free to check out the videos I have there. I look forward to serving you and helping you lifeguard your legacy.